there. I'd like to thank everybody for joining us today and welcome you and for the opportunity to be able to speak to you on the Families First Coronavirus Response Act. My name is Cara Turner, and I am the owner of Turner HR Services here in Whatcom County, a human resources business doing HR consulting for the last 20 years. And prior to that, filling an HR director role in a couple different agencies. So Tiffany, should I go ahead and start?
Sure.
Great. Okay.
Liz will jump in when she's here. So
okay. That's great. Okay. So I appreciate everybody joining us. I know that right now everyone is trying to juggle a lot of different issues as well as decipher a lot of different information. So I appreciate the opportunity to be able to speak on this specific piece of law that's come out in response to the COVID-19. And what we're going to focus on today is specifically the Families First Coronavirus Response Act and the two pieces of leave related to that act. You know, when you go to presentations that attorneys provide, their caveat is always, I don't provide legal advice. And my caveat today is I'm not an attorney, so I definitely am not providing legal advice. But I've been practicing for the last 30 years, human resources, and have attended and watched more webinars in the last couple of weeks than I care to even count. So I'm doing my best to kind of stay up on all this information and then help employers implement some of these leaves within their workplaces and sort of decipher what was intended with the law. So the Families First Coronavirus Response Act was signed and passed into law March 18th, a quick response to the coronavirus outbreak. And the act itself addresses a number of issues in addition to leave. It addresses grants and access to unemployment, as well as addresses issues related to healthcare coverage and testing of COVID and a number of other areas. But today we're just going to focus on the leave piece of it. So the two areas of leave that I'm going to talk about are the Emergency Paid Sick Leave Act, and then which is a subset of the Families First Coronavirus Response Act, and then an extension of the FMLA for employees that meet certain criteria, which we'll talk about. So let's start by talking about the Emergency Paid Sick Leave Act. That law, you know, the law was signed into March 18th and became effective April 1st and will extend through the end of this year, December 31st, 2020. So what that piece of the law and leave says is that for employers that have 500 employees or less, and there's an exemption there for healthcare providers and emergency responders, and they are working on providing further clarification, but that initially is what was written into the law, is that exemption to the sick leave for those groups. So if you're an employer that has 500 or less employees, you are required to provide for full-time employees 80 hours of this emergency paid sick leave. For employees that are part-time, you would provide a prorated amount, and that's based on their scheduled hours. So if an employee, say, works half-time 20 hours a week, you'd be providing 40 hours. If they have a variable schedule, then you would be looking at a 6-month average of those variable hours to determine what prorated amount of sick leave you'd be providing. So the law identified 6 reasons that you could access, an employee could access and use this emergency paid sick leave. And they are differentiated 1 through 3 as opposed to 4 through 6 because they're compensated differently. And I'll cover that in a minute. So I just want to start by just covering what are the reasons that you can use this emergency paid sick leave as an employee. So the first one is subject to federal, state, and local quarantine or isolation order related to COVID-19. So there's been a lot of conversation around this because, you know, we'll talk more about it, but the fact that there is a quarantine doesn't automatically make an employee eligible for accessing the sick leave, especially if a business closes or if a business has a slowing of the business due to the COVID and puts an employee on part-time hours. Those are not reasons that an employee would access this sick leave. And we can talk more about that when we get to the Q&A. So the second reason is advised by a healthcare provider or self-quarantine due to COVID-19 concerns. The third reason is experiencing COVID-19 symptoms and seeking medical diagnosis. So those first three reasons have to do with an employee using the paid sick leave for themselves in their own use. Differentiating between that and the next three have to do with needing leave to care for someone else. So number 4 is caring for an individual subject to federal, state, or local quarantine or isolation order, or advised by a healthcare provider to self-quarantine due to COVID-19 concerns. That individual doesn't have to be a family member. It could be somebody living in your home that you're caring for that's not a family member, or it could actually potentially be a neighbor or somebody that you are providing ongoing care for. Number 5, caring for an employee's child if the child's school or place of care is closed or the child's care provider is unavailable due to public health emergency, which is the COVID. Number 6, experiencing any other substantially similar conditions specific to the Secretary of Health and Human Services in consultation with the Secretary of the Treasury and the Secretary of Labor. So that was written in, they weren't sure what all things may come as a result of COVID-19. And so this, if there's some other health care issue related to COVID-19, then employees can also use the emergency paid sick leave for that as well. So as I mentioned, the first 3 have to do with caring for yourself, and then the next 3 have to do with caring for someone else. And the law was written in to differentiate between the 2 as it relates to pay. So reason 1 through 3, an employee would receive full compensation for their sick leave at their current rate of pay. And there is a limit. So that limit is $511 per day or $5,110 per employee. And then reasons 4 through 6, an employer is required to compensate an employee 2/3 of their rate of pay, up to a limit of $200 per day and $2,000 total per employee to care for others. So an employer has the option to do 100% pay for any of the reasons 1 through 6. So the law just requires a minimum of the 2/3 for reasons 4 through 6. So you always have the option to pay 100% if you so choose. If you're a public sector employee, you want to look at, some of my public sector clients aren't doing that because they feel like that would be a, gift of public funds and a potential audit issue. So some other things about that emergency paid sick leave is an employer can't require an employee to use their own leave prior to accessing that. The employee can choose which leave to use first. If it's, say, an employee needing leave to care for a family member, they want to receive 100% of pay first. They might use their sick leave first and then use this leave. Or they can choose to use this and then use their sick leave. You also can't require employees to find their own replacement prior to using leave, or, as part of the leave process, you have to assist them in that. An employer can't retaliate against an employee for requesting or accessing that leave. And it is a total of 80 hours for any of the reasons. So suppose I need a week off for myself, and then that would leave 40 hours remaining. And suppose later in the year I need another week to care for a family member, I would be eligible for that other 40 hours, but it's no more than a total of 80 hours under the emergency paid sick leave. And it at this time is not intended to carry beyond December 31st. So it's a use it or it's gone at the end of the year unless there's changes to the law. So the second piece of leave related to this law had to do with expanding the FMLA. And FMLA is the Family Medical Leave Act. It's a federal law and currently applies to employers 50 or more. And while it, for qualifying reasons, allows an employee to take 12 weeks of leave, it doesn't provide any type of paid leave. An employee would use their own leave and then be on leave without pay. This makes an expansion in the sense that it applies to not just employers 50 and over, it applies to employers of 500 or less. And it does provide for compensation for the qualifying reasons. So the law was written and said small employers could apply for an exemption if it jeopardizes business viability. So they're asking businesses, if you are able to document that using this, allowing employees to use this leave would cause you to go out of business or jeopardize your business viability, and they aren't always clear about what that means, but they say document it, then you could potentially be exempt from this law. So the eligibility for the law, for employees to be eligible, FMLA, the federal law I was referring to, employees have to work 12 months and work 1,250 hours prior to becoming eligible. For this law, there is no requirement of the amount of hours that an employee would work, and the employee has to be working at least 30 days prior to the need for designated leave. So they could be hired this week, 30 days from now, then they would be eligible to take this leave if they needed it. So the law allows for 12 weeks of job protected leave for an employee who is unable to work or telework to care for a child. And they define that as a child 18 years or younger if school or childcare is unavailable. So the first 10 days of that FMLA leave, that 12-week leave, are unpaid. And the law, specifically refers back to the emergency sick leave. Those 10 days, you can access the emergency sick leave. And then from that, the remaining 10 weeks would be paid. And it's paid at the same amount as that emergency sick leave, which is the 2/3 regular rate of pay for up to $200 a day or $10,000 aggregate for the entire time of leave. So what I'm finding that right now, where people are accessing this has more to do with employees being not so much that they're at a work site and their daycare or their schools closed. Most of the situations I've been working with employers on is employees are working remotely and the school is also remote, and parents are trying to juggle homeschooling as well as doing their full-time work, and finding that to be quite challenging in many cases. So employers have the option, or employees can request an intermittent leave, meaning they can use some of this FMLA to take periods of time off either during the week or every day to assist them in caring for their children, whether it's homeschooling or childcare situations. So, what I'm finding is that employees are making requests such as work in the morning maybe, and then take a middle of the day and assist their children or watch their children or share childcare with a partner, and then going back to work in the afternoon, so maybe taking 2 or 3 hours a day, or sharing childcare responsibilities and doing every other day. So some sort of an intermittent process is what I'm seeing most commonly this FMLA being used for. So the law does say for employers that are 25 or more that they must restore the job, the same restoration rights as FMLA, to the same or equivalent position. Fewer than 25 employees, they're excluded if the position no longer exists due to an economic downturn, which is sort of interesting. They make this comment because that is the same. If an employer has to downsize during this FMLA process, whether it's an FMLA for a federal reason or FMLA for this reason, you have the ability to eliminate positions while someone's on FMLA. You just have to make sure that it is in no way appears to be retaliatory for the person taking FMLA. So that person would have been laid off regardless of whether they're on FMLA or not. So, and again, there are some exemptions for this rule for healthcare and emergency responders. So some other paid leaves I just want to make sure that you're aware of, and I'm sure you have it in your organization. That is, effective January 2018, we had the Washington paid sick leave law that said for any size employers that employees working receive 1 hour of sick leave for every 40 hours worked. And those unused sick leave balances, they can carry up to 48 hours over from 1 year to the next. So they can use them for themselves or an eligible family member. And then we also have the Washington Paid Family and Medical Leave that took effect January 1st, 2019 is when premiums began being deducted, and employees at the beginning of this year were eligible to start taking leave. So that is managed by Employment Security, which is also handling all the unemployment claims. And so they're very busy these days, whether it's unemployment or Washington Paid Family Medical Leave. Under that law, if an employee, the eligibility is determined not by employer, but by employee. If an employee is working 820 hours within the preceding 12 months, then they are eligible for up to 12 weeks. It's a partial pay, and that's based on how much the person makes. And they also receive job protection, and potentially if they're on an FMLA at the same time as PFML, then their benefits would also be covered during that time. And then we also have, as you know, FMLA. So if you're an employer of 50 or more employees, employees are eligible to take up to 12 weeks of FMLA as well for serious health condition for a variety of reasons. But as it relates to COVID-19, it would likely be an employee needing to take time off for their own serious health condition that may have developed due to complications, or a family member to help assist with a family member. So one more slide, and then I'll open up to any questions that people might have. So there is a great frequently asked questions on the Department of Labor's website. They have just Q&A. I think it's 18 questions and answers. The ones that I am seeing that I thought were worth covering with this group, the one question that comes up a lot, so suppose I'm closing my work site, some folks have closed work sites, does that mean that they get this sick leave or this family leave while the work site is closed? And the answer to that is no. Work sites that have been closed, those employees are eligible for unemployment, so they would go on unemployment. And then once they return to work, then if this applies through the end of 2020, so if there is a need that arises, then they would be eligible for that during through to the end of the year. And then also the question came up, if my hours are reduced because of lack of work, could I take this sick leave for that? An employer could allow them to access it, but they're not required to do so. So it says, if hours are reduced due to not having work available, you may not use this leave because you were not prevented from working the hours due to COVID-19 qualifying reason, even if the reduction in hours is somehow related to COVID-19. I mean, often the business downturn is connected, but that's not specific to, they're saying no, we'll just leave it at that. Will my healthcare coverage continue while I'm on this leave? So if an employee does have healthcare coverage, then they're entitled to continue the coverage during the leave under the same terms as if they continued working. So they would still make their copay, but would continue that insurance during that leave. And then the last one is, and I've got this question quite a few times, so under FMLA, you get 12 weeks of leave in a 12-month period, and each employer is able to define what their 12-month period is, and hopefully you have that defined in your policy. So the question was, is this 12 weeks that I take for my school being closed or childcare being closed, is that in addition to the 12 weeks that I get under FMLA? And the answer is no. It's a total of 12 weeks. So suppose I had surgery last fall. So often the definition that employers use is a rolling 12-month period. And if I had maybe surgery last fall, and then now I'm in this current situation where my school's closed and I need some of this leave related to homeschooling my children, can I, it would be a total with that surgery and this of 12 weeks, no more than 12 weeks. All right. So that completes the slides. I'm just taking a peek at the chat. I don't know if anybody has any follow-up questions.
Can you, this is Byron Mannering from Bridget Collins. Can you go over more about just the use of both the leave opportunities for individuals that are caring for kids that are out of school right now? Just kind of lay that out a little bit better, or maybe for more explanation around that. I'm not sure.
Okay. So the main mandated leave for school closure and kids being home and employees needing to balance and care for their children that are home from school is that I'm going to go back a slide here. This expansion to FMLA. So an employee is eligible for 12 weeks. That could be 12 weeks full time. They could say, I can't, due to my situation, and most aren't doing it as it relates to having access to remote work. If you have access to remote work as an employee, often employees are able to do partial work, but some are saying I can't do full-time work. So they can use this 12 weeks and they can use it intermittently to do my responsibilities, and then I can use the access this 12 weeks on a prorated amount to care for my children, either school or for childcare reasons. So 12 weeks on an intermittent basis is 480 hours. So, it just depends on, I work out with my employer, maybe I need 20 hours a week. So then, you can do the math out how long that would last. It actually probably would last more than 12 weeks because it's 480 hours when you're using it on an intermittent basis. So I don't know if I hope that answers your question. Feel free to follow up if you have another one.
Nope, that's it. Thank you.
Okay, great. And I see Heather has a question. Wait, sorry, I'm going to see. So if you are self-employed, how do you get the forms to file for unemployment, or can you qualify for the FFCRA? Great question. So I would check with all of this is accessed and done through, well, actually you'd be paying yourself. If you're self-employed, this is not money that's coming from the state. So all of this that I've talked about so far, with the exception of the Washington paid family medical leave, the other things that I've been talking about related to the Families First Coronavirus Act, that is money that comes from the employer. So you'd be granting yourself leave and paying for it yourself. If you're asking, can I access the employment securities, the Washington paid family medical leave, you would set up an account through employment security and apply for, if you were sick, the leave through that. So hopefully that answers that. So we have another one here. What if we have an employee who had a stroke and there is a chance that it would be brought on due to the stress of working more hours due to COVID? Would she qualify for the federal leave? Yes, regardless of, it doesn't, so she would, let me think about this for a minute here. So you're asking, would she have access to the 2 weeks? She definitely, the federal, she would be eligible for FMLA. I don't know, that's a good question. As an employer, you can grant that emergency sick leave. So I don't, I think if you made a connection, and especially if you had a healthcare provider that said this is related to COVID, you could cover it. The thing about staying within the definition, some employers are being really careful to stay within the definition because they want that money reimbursed, and that some of this money, I can't speak to all the accounting pieces of it, but, through breaks on taxes, your Social Security taxes, that is how that's being handled, but you have to be complying. They're only going to reimburse up to the limits. So if you're paying over the limit, that's going to be the employer's responsibility, or if you're paying outside the definitions. So I guess I would definitely, I maybe seek advice if you're worried about getting reimbursed. Otherwise, you're welcome to provide that. And that person, if you're an employer that's 50 or more employees, would be eligible for FMLA and the Washington paid family. The health condition in and of itself would qualify them for the Washington paid family medical leave, which they would apply with employment security. Let's see, if an employee, I have an employee who is coming off PFML and the employee is very wary of returning to the work site. Can she file for the FFCRA? If her health care provider says, she's not, if her healthcare provider due to her health condition is telling her to quarantine, then she would be eligible for it. Okay.
Cara, this is Liz. Can I just ask a quick question? I want to go back to the one about the person who is self-employed.
Yes.
So if I understand this all correctly, then if they're paying themselves and they qualify, it's really a tax return issue because you get to somewhat look at that as a refundable tax credit.
Yes, apply for, yeah. And again, I would encourage people to work with their accountants to do this, but yeah, there will be a tax credit that you can apply for to within Social Security to apply towards that pay that you've given yourself that falls under this FFRCA.
Yeah, and I just wanted to add that we also have for our partners access to some specialists at Larson Gross. So some of these really specific questions, we might be able to connect you to somebody there who might be able to answer the tax part of the question.
Great, thank you, Liz. Yesterday, the Whatcom Business Alliance did a really nice presentation, Erica with the public health department, and then they had Larson and Gross presenting, and then a couple other presenters, and did a really nice job of speaking to the PPA and the tax credits and a variety of different things related to small business loans. So you might be able to access those who want to see that general information. They might have it on WBA's website.
Yeah, and we have a recording of the piece that Larson Gross did for our partners as well.
Great. One thing I want to mention that's unrelated to this, but is popping up right away, and I have been in contact with 5 of my clients that as of yesterday received false unemployment claims. One as many, the employer is 85 employees and they received 10 false unemployment claims. The rest of them received anywhere from 1 to 4. So I would highly encourage you to keep your eye on your unemployment information, what's coming through, because the unemployment will give you, and they'll give the employee a notification that they've applied, and they'll give you a notification. And depending on what the person who went into Employment Security's website did to set it up, the employee may never know that it might not go to the employee at all, their address. It might go to a different address, but the employer will for sure get a notification saying this employee applied for unemployment. And in all those cases, they were active working employees, essential workers working. And so, there's a process, and I can share with North Sound, and if you want to share that out, an article about what to do if you find that somebody's applying for unemployment that's a fraudulent claim. Not only contacting Employment Security, but some other steps your employee should take, because it means that somebody has applied for unemployment using their Social Security number. Okay, let's see. We have an employee who says that she gets severe anxiety about wearing a mask. When she returns to the job site, she will be required to wear one. What if she refuses to do so? You're starting to give me those legal employment questions. Yeah, that's a great one. I guess I would continue, hopefully, perhaps working with an employee assistance program. I mean, I think talking with the employee about what accommodations might be done make her more comfortable, and maybe, just working with that employee. I don't know if that employee is in a common area or is in a private office, whether some accommodation could be made where she's wearing it and then for a period of time is able to take it off in an enclosed space. That's a tough one. And I'm not sure I have one final answer for it, but I think having conversations with the employee and asking them, we're all going to have to stretch in a variety of ways, and how she might be able to meet that requirement. I'm also curious if it's, if it's something that's ends up being documented by a doctor, what the conversation might be. What do you have to make reasonable accommodation, and is there remote working options for her, partial remote working options for her? So I don't know if she has a documented health issue that you'd have to accommodate, or just refusing. I would say get legal advice before you take any type of employment action related to it. In the meantime, just continue to work with the employee through an interactive process. Yeah, we'll be sure to make the slide deck available. Yeah. Great. Thank you, everyone.
So Cara, I may just try and close us up if there aren't any other questions. I think that our desire was really, you've been so amazingly helpful, obviously, to us and our team, and recognizing that we have all of these contractual relationships with providers around delivering care and services. And what the coronavirus did was also just realize that so many of our partners are also small employers, and wanting to have a way of sharing some of this information with them as they're making decisions around remote access and what does that mean and what happens with staff, along the way. So just thank you for being willing to get on and have this be recorded. We'll share the recording and your slide deck out probably with our next update that Hillary sends out.
Thank you. And thanks for the opportunity. Appreciate it.